Right, I think we're now on cue. Brett Bowker is giving directions from the back of the seminar room, as is his wont. Those of you who think that barristers are self-employed would only need to work on Green's List for a very short time to know that that's not the case. And ironically, I have a clerk who comes in to who barracks for and had played for Richmond for many years, although of course he shares the collective shame of having played in the 1973 grand final when a man called Neil Baum hit the equivalent of Mother Teresa playing for the Carlton Football Club. His name was Jeff Southby, but Michael has the nerve to come in and bag Carlton only because Richmond has won its last five games. But to more important things, as some would perceive it, we're now going to talk about I think the very interesting topic of default notices and some very practical insights which Peter Little is going to discuss in his paper. Peter, as you might know, has been a barrister like John for many years. He's done many cases in property law and arguing about completion requirements and default notices and whatever. Before coming to the bar, Peter was a lecturer in contract and property and taught, I think, as well at the University of Melbourne for about 5 years or so, and then worked at Baker and McKenzie for a time. Peter, I'd like to welcome you to talk about default notices and other interesting aspects of the law of property.
Thank you, Paul. Good morning, everybody. Thank you for coming tonight, this morning, and it's a pleasure to speak with you. Property law has a special place in my heart, and I only want to have a discussion today, as most areas in property law is a discussion. What I plan to do is not talk directly to the paper, but just discuss the points that come out of the paper. Everything I'm going to say is already in the paper. I only want to hit the key points and what I hope you can take away in a digestible form. And I have two main areas. One, I want to explore what may be the pitfalls of developments with rescission notices, and then to dismiss or dispel a myth about duty to mitigate. I'll leave a couple of minutes at the end for questions for John and myself, but we'll finish right on time at 8:45. There has been a significant change in property law. We're now back to a stage where we need to interpret the terms based upon our common law principles. The legislative backing that used to be there is no longer there. What that means is it's a bargain between the two individuals. Every contract in property law is now arguably separate, and you need to examine the terms separately. Now, we know that there's a general conditions in property law contracts. They are given, they are standard. But what we're seeing is significant changes to those general conditions with the special conditions. And those special conditions can override those general conditions. And what I'm seeing that's hitting my desk is special conditions which significantly outnumber the general conditions and actually almost wipe out the general conditions. And that's one aspect. But another aspect is that we can be creative, or you can be creative of what you want in your property contract. But be careful of how it is interpreted. One aspect that comes out of interpretation is if there is a fault or a breach that requires you to issue a rescission notice. Now, today I'm going to speak about multiple rescission notices and just hit the key points. I'm seeing a number of situations, once again, hitting my desk where there's multiple rescission notices. What's the effect? What's the consequence? What do you have to be careful about? If I can add, this particular point on rescission notices comes out of a number of papers that I've given on rescission notices, and other or earlier papers have examined what there needs to be in place for there to be a valid rescission notice and damages that flow from that. If you want a copy of that paper, my email is in this paper, and just email me, and I have no hesitation in passing on my earlier papers on rescission notices. So we're going to look at the pitfalls on multiple rescission notices. Then I want to spend most of my presentation this morning looking at the duty to mitigate. And this comes out of a particular case which is Supreme Court of February of this year, which is the Portbury Developments Co. Proprietary Limited versus Odeon Investments Proprietary Limited and others. It's a case before His Honour Justice Gard, which was handed down in February, and it's an excellent up-to-date thesis on duty to mitigate, if such a term exists. But the end point, which I'll start and I'll end with, is that in this area where there's a fault, a dispute, a breach, the question is what are the facts that are relevant? And once again, in this area, that can only be determined clearly by a judge. So these issues are factually dependent, and so it's necessary not only to look at the law, but if you have a dispute, it's to identify what the relevant facts are. And in essence, I don't mean just the facts, I mean what evidence do you have, whether oral or in writing? What's the weighting of that evidence? And really, it's what a judge is going to determine of that evidence objectively, because that's what's going to determine the results in this particular area. Let me start with multiple rescission notices. Now, I'm not sure of your experience, and I'm interested to know, but I certainly have seen more situations of multiple rescission notices. Why is that? Well, it can be that your first rescission notice is arguably invalid. You never really know until a judge tells you clearly one way or the other. Some people do it out of sheer caution, but one must be very careful about a rescission notice, and that is if you have lost, time is of the essence. You know, in a standard form contract, fundamental term, time is of the essence. But certain conduct and preceding behaviour can lead to a conclusion that time is no longer of the essence. Almost in every situation where there is a rescission notice, there is also an adjournment or a postponement of settlement. Often happens. But other situations, or if there's multiple postponements of settlements, you can lose that notion that time is of the essence. If you then issue a rescission notice, expecting that you are terminating the contract because they haven't satisfied, let's say, for example, the settlement, and time is not of the essence, your rescission notice does not terminate the contract. It only makes time of the essence. It changes time of the essence to become a more fundamental term. But the problem is you think it's been terminated. Then you go away and you sell the property, if you're the vendor, but that gives rise for the purchaser to turn around and say, you have evinced an intention not to fulfil the contract, you have repudiated the contract, and I, the purchaser, will accept that repudiation. So, one moment you're in the position of power, the next moment you are not. So, one must be very careful with the first rescission notice. And so that can be a reason why there needs to be a second rescission notice. Obviously, there can be a problem with the first rescission notice. Now, what I'm also seeing, and I only see the things that go wrong, and I'm seeing a lot of things hitting my desk where there are a lot of real estate agents and non-lawyer conveyancers writing up special conditions, and invariably they're wrong, which gets into troubles, and by the time they hit my desk, the conveyancer, lawyer conveyancer has issued a rescission notice already, that's wrong, and then we're in trouble already. Do we issue a second rescission notice? What do we do? Etc, etc. So there could be reasons why there needs to be a second rescission notice. Some actually just do it out of sheer abundance of caution. But either way, it leads to complications. Now, if you have a situation where there is multiple rescission notices, or there is a need to issue a second rescission notice, you first off ought to make sure that your second rescission notice does not overlap with your first rescission notice. And what I mean by that is, if you have first rescission notice, it extends for 14 days, the standard term. I'll pause there for a moment. Please note that the 14-day requirement is not set in stone. What is required is just a reasonable time period. The courts accept 14 days, but legally it is reasonable time set upon the facts of the situation. Now, invariably 14 days is standard, but don't think that it has to be 14 days. I wouldn't have anything less, depending on certain situations, but there is always a possible argument to overcome a rescission notice to say that the time given, 14 days, is in fact not appropriate, but that needs to be specific facts in place for that to occur. But let me go back. Now, first off, if you are to issue a second rescission notice, ensure that it doesn't overlap the time period on the first rescission notice. And what is critical is, before issuing the second rescission notice, is to obtain the evidence or the instructions of what was said and done leading up to, one, the first rescission notice, and second, everything said and done leading up to what would be the second rescission notice. And you need to evaluate at what stage is this contract in place or not, or what are the issues. Because in fact, it could be still a situation where your first rescission notice is invalid for whatever reason, but time is still not of the essence. So you need to make time of the essence first before you are entitled to issue the second rescission, entitled to rescind the contract. Let me just talk about one or two cases. There is a case called Rona and Shimden, which is a New South Wales case in 2005. In that case, there were two rescission notices. The first rescission notice was issued, but what happened in the second situation is this time the vendors issued a second rescission notice but had it on a without prejudice basis. And then they said it's without prejudice to the rights that contained in the first rescission notice. I'll pause there and I'll come back because I have an issue with that particular situation. But Justice White went on and concluded that the giving of a notice to complete may give rise to an estoppel, which precludes a party giving the notice from asserting that the contract had been terminated. Here, in the particular case, the purchaser did not do anything consequent upon the service of the notice, which could create an estoppel. Estoppel aside, he said, the service of a notice to complete without prejudice to a prior notice to terminate takes effect as an offer to receive the agreement, capable of being accepted by performance in accordance with the terms of the notice to complete. He found that this was valid. It's a sort of offer, and this approach has been relied upon, has come from an earlier case, which is Lohar Corporations Proprietary Limited versus Dibu Proprietary Limited, and it was applied in Victoria in the Naval and Military Club versus Southall case in 2008. But it seems to be accepted to allow a second rescission notice and not to interfere with the first if on a without prejudice basis. But in 2010, we had the case, which is U108 Proprietary Limited versus Sin Fan. This is a Supreme Court case before His Honour Justice Hargrave. And in this case, there was two rescission notices. One was issued, and then the solicitors for the purchasers wrote to the vendor's solicitors and criticised the first rescission notice and said it's not valid. Then, for reasons that I cannot explain, the solicitors for the vendor sent a second rescission notice within the 14-day time period of the first rescission notice. So, first rescission notice got 14 days. Before the expiration of the 14 days, the solicitors for the vendor issued a second rescission notice. What's the legal position? Which one's valid? When does the purchaser supposed to satisfy the requirements of that, or which rescission notice? Now, in this particular case, there were numerous and various other errors and problems with the rescission notices, but another relevant one for this particular point is the second rescission notice came with a covering letter, which it's required to do, but the due date that they stated on the covering letter was the wrong date and different to the date in the second rescission notice. It wasn't hard for His Honour Justice Hargrave to find that and I quote, a reasonable person in the position of the purchasers might entertain a doubt as to whether, in order to avoid the rescission of the contract of sale, they were required to pay the balance of the purchaser price within 14 days of the first rescission notice or within 14 days of the second rescission notice. Both notices were therefore invalid. His Honour did make a particular point that there was no reference in the covering letter for the second rescission notice to withdraw or to take back the first rescission notice. And that's something that you may want to consider. I had a situation recently where there was a first rescission notice which was wrong. Within the time period of the first rescission notice, we withdrew the first rescission notice and terminated on the basis of acceptance of a repudiation. We'll see whether the judge agrees with me on that in due course, but that's the process that we've taken. Now, if I come back to the main case that I want to talk about, which is the Portbury case, the relevant facts in this case dealing with multiple rescission notices, in December 2008, the vendor entered into a contract to sell what is undeveloped land. It was a large block of land that was to be at a later stage developed and subdivided, and the cost was $6.5 million. The contract was varied a little bit later, where there was different payments to be made, and that gave rise to an argument whether it was a terms contract. But there were certain parts of the deposit paid, but in the end, not all the amounts were paid, and there was no settlement. Settlement was supposed to occur on the 18th of December 2010. After that had come and gone, on the 18th of January 2011, the vendor issued a rescission notice. 14 days, that expired. But then on the 31st of March 2011, the vendors issued a second rescission notice. Now, what occurred in this particular case was there was an argument from the purchasers back to the vendors to say that you had not served appropriately, whatever that means, the rescission notices on the parties. There was an area of dispute. One of the fundamental questions was the purchaser had nominated another company, Gold Care Developments Pty Limited, as the party to purchase the property, and there was a question whether the rescission notice had been served adequately on all the appropriate parties. Arguably in this case, out of an abundance of caution, the vendor issued a second rescission notice. Now, this did not become an issue in this particular judgment, for there was no correspondence, no discussion, no letters that really occurred first within the 14 days of the first rescission notice, after the first rescission notice, and within the 14 days of the second rescission notice. In the end, the court decided that the first rescission notice was valid and the contract was terminated at the end of the 14 days of the first rescission notice. Interestingly, in this case, there was no question about a without prejudice aspect to that. And my question in relation to without prejudice is, can you rely upon the second rescission notice to terminate the contract if it is on a without prejudice basis and equivalent to some sort of offer? I think there's an issue with that. if it is on a without prejudice to the first rescission notice, to what extent is the second rescission notice actually an offer? How is it worded, and how is it to be applied? I think there's still more to uncover in relation to that. The second issue is interest. If you have two rescission notices, which one's valid? When does your interest kick in? If you take a standard property, most houses $1 million, standard interest rate in the general conditions is 12.5% at the moment. Interest rate calculates at approximately $10,400 per month at the normal penalty interest rate. So if your first rescission notice doesn't work, it could be argued that your first rescission notice perhaps is not entitled to terminate the contract, but it still triggers the interest rates requirement within the contract, and you can at least get an accelerated or a higher interest rate, and $10,400 per month may cover their legal costs. So, but you also have to be careful with the penalty clauses in the property law contract, because you've got to sell the property arguably within 12 months. And if your first rescission notice didn't work, how far later is your second rescission notice? And if you sell the property 12 months after the second rescission notice, that may be out of time for the first rescission notice. So once again, great care with rescission notices. Let me leave rescission notices there and move on to what is a duty to mitigate. The duty to mitigate I put as a question mark. Is there a duty to mitigate? The central question is, how can there be a duty to mitigate when you're talking about liquidated damages clauses? They don't apply, prima facie. There is no duty to mitigate for liquidation clauses. This is a central question. I mean, the purpose of the liquidated damages clauses is an agreeable figure or process between the parties to solve what is a dispute. Second to your general principles to obtain damages for breach of contract. I always think it's worthwhile to go back to the relevant clause, and it's always worthwhile to spend a moment focusing on what is the actual term. The liquidated damages clause in the general conditions is 28.4, and there's many parts. First off, if, and I'm assuming that's a valid rescission notice and I'm only focusing on the vendor is entitled to up to 10% of the purchase price forfeited to the vendor as the vendor's absolute property, whether the deposit has been paid or not. Please note it says up to 10%. If you're, let's assume it's a standard domestic contract for sale of land, and for reasons that it was just been determined between the parties, it's only 5% deposit, can you claim the extra 5%? Arguably not. You're entitled to up to 10%. Doesn't say automatically you're entitled to the 10%. The vendor is entitled to possession of the property, and what is relevant to us, in addition to any other remedy, the vendor may, within 1 year of the contract ending, retain the property and sue for damage for breach of contract. But more importantly, and this is the quintessential subsection, resell the property in any manner. I've underlined that because that's an important phrase that His Honour Justice Guard looked into in the Portbury case, and recover any deficiency in the price on resale and any resulting expenses by way of liquidated damages. And the vendor may retain any part of the price paid until the vendor's damage has been determined, and may apply that money towards those damages. And finally, any determination of the vendor's damages must take into account the amount forfeited to the vendors. We saw that in what was the previous 7th schedule. Let me come back to and look at how that part of that sub-clause is applied, set within the context of Portbury. Some relevant extra facts that came out of the case relevant to explore this question about is there a duty to mitigate. First off, what happened once the rescission notices had been issued, what the vendors did is they engaged an expert in the area to sell the property. Knight Frank has extensive experience to sell this type of property, being a property that was ready for, or not ready, but later down the track to be ready for subdivision. They're obviously got a good reputation, and the vendors left Frank Knight to come up with a strategy of how to sell the property. And they sought to sell it by public auction. There was an auction on the 29th of June 2011, and it was passed in. The final offer was a valid offer by a Mr. Facey, who was a representative of a company which is Park Leah Estates Proprietary Limited. The last offer was $2 million. Remember, the property was purchased for $6.5 million by the vendor in the first contract by Otian. What occurred shortly after the auction, the discussions were entered into, and the vendor sold the property to Park Leah for $2.1 million. Huge difference. Great argument for a duty to mitigate. And it even gets better because a couple of months later, out of a great deal, Park Leah then on-sold the property to Builtex Group Proprietary Limited for $6 million. How could you lose an argument, a duty to mitigate? Well, in fact, they did. Now, what is central to this case in Portbury, there are a number of proceedings. This one was that Portbury brought legal proceedings against Otian, Goldcare and the guarantors, and relied upon the particular liquidated damage clause that we referred to, and sought the difference, which basically, after taking into account the deposits and the other expenses like real estate expenses, selling expenses, there was a shortfall of about $3.1 million. Otian argued by way of defence that, in fact, Portbury had breached its duty to mitigate its loss and it was not entitled to claim its loss. And in fact, that's the argument. If there is a duty to mitigate, as we have in common law contracts, normal commercial contracts, the effect of that actually stops, let's say it's the plaintiff, from claiming the damage. It doesn't stop them being entitled to the damages, but it just stops them being paid or entitled to claim that amount of money. That's the effect of a normal duty to mitigate. Now, what came out, His Honour Justice Guard focused on in any matter. So you can sell the property in any manner, any manner. Now that's very broad and it's open to various interpretations, but the court went on and said that if there is some sort of obligation or duty, then there are three approaches. The first approach is your standard duty to mitigate, as we know in commercial contract law. The vendor acts unreasonably in failing to minimise its loss arising from the purchaser's breach of contract, and any damages arising out of the breach will be reduced to the extent to which the vendor's loss would have been reduced had the vendor acted reasonably. So that's the standard. The second approach was to take an analogous approach and say, well, this is similar, surely the obligation is similar to that which a mortgagee ought to exercise when a mortgagee is exercising its power of sale granted under a mortgage security. I have issues with that, for I see that that sort of obligation deals with property law issues, whereas arguably liquidated damages clauses deal with contract law principles rather than proprietary principles. But the third approach, which I think is an acceptable approach, is where there is an implied term, not a duty to mitigate. There's an implied term inserted into the contract. The implied term that the vendor will exercise the power of resale in a reasonable manner. Exercise the power of resale in a reasonable manner. Now, I'll come to some problems with implying terms in the contract, but why I think I would submit this is acceptable is this is not too dissimilar from the generally accepted if not arguably universally accepted, principles that come out of Renard Constructions and versus Minister, and that is, wherever there's a power to exercise certain rights in a contract, like a right to terminate, then that power ought to be exercised reasonably. And this is arguably, analogously, the same. If you have a right to resell the property, it ought to be exercised reasonably. The $64 million question is, well, what does that mean? In my paper, I go in and I explain and explore the first and second approach. I'll leave you to do that yourself. For His Honour Justice Guard said, all approaches seem to be acceptable, but I don't need to decide which one exactly because the results will come up the same, and this is the result. So he hasn't, I would submit, given a clear view of what which principle is more appropriate, but I would submit that you have a better chance, if you wish to argue a duty to mitigate, you'd have a better chance to argue that there's an implied term to act reasonably. It still is a Hail Mary argument because it's very difficult still to get up on. Now, when you have an implied term, it means that you need to act reasonably, and thankfully His Honour gave us a bit of an indication of what that means, and it includes you need to act reasonably when dealing with the price, the time of sale, the conduct and the form of the sale, and I would submit also that it is an interesting question, especially with a parcel of land like in Portbury, because why there was a lot more money for the resale to Buildtex was the settlement date was years later. It was a lot longer. And so the global economic crisis hit at that particular point. The judge said that was an important factor, the global economic crisis. In essence, there was just no purchases. So it was reasonable to on-sell at 2.1. Further, there was extra evidence that they had to sell because of the pressure on the banks. They were in extensive debt and the bank required them to reduce their debt. But also why there was such an increase in the resale was there was different factors like extended period of time to settle, and that was many years later, which put things into a different perspective given the global economic crisis. So you need to just what is considered to act reasonably in relation to those factors. Now, let me just make one or two points about an implied term. Property law, they're almost always in writing. By default, they have to be technically in writing. You may have equitable principles, but they need to be in writing. And therefore, if you're going to imply a term into a contract, you need to apply the Cadelpha tests of when a term can be implied. And I'm sure you're all familiar with it. There's 5 basic steps. This is all in the paper. But it must the alleged term must be reasonable and equitable. It must be necessary to give business efficiency to the contract so that the term will be implied if the contract is effective without it. It must be so obvious that it goes without saying, and it must be capable of clear expression. It must not contradict any expressed terms in the contract. It's a high threshold to imply any term in a written contract. So first off, you've got that threshold, and that's where I think you'd use an analogous argument of Renard. But apart from that, once you actually get the implied term inserted, then you have a question about its application and whether there's enough evidence for that. Now, in essence, the court found in Portbury that Portbury did not act outside what is an implied term, and they did act reasonably. So, in conclusion, one must be careful when dealing with multiple rescission notices, examine the things, the preceding conduct, communications and correspondence, try to get it right the first time. But it's also important to ask and identify what evidence exists to determine how strong and determine how strong that evidence will be. It's obviously a question for the judge. Thank you very much.
Thanks very much, Peter. I think I've got to get out more because I've learnt about swerve room, and then despite my own background, I'd never heard the expression Hail Mary argument before. I know when that's said to me, I am in deep trouble and the game is over. Thank you very much, John and Peter. Peter's reference to real estate agents and conveyancers made me think a little bit more about childhood reading. There was John talking about Lewis Carroll. Listening to Peter, I was thrown back to E.A. Milne. Most of you, because of the demographic here, won't remember E.A. Milne, but some of us were read to poems of E.A. Milne as kids and read the same poems to others. But there was, do you remember George Weatherby took his mother to the whatever? But there was one little prayer, God bless mother, God bless father, etc., etc., etc. Peter's reference to real estate agents and conveyancers drawing their own contracts, often to get a purchaser just over the line, made me think that for some of us we should end the day, God bless real estate agents and conveyancers. If it were not for them, Peter would still be in academia. John would be a film star in Hollywood, and I don't know where I would be. But thank you very much indeed for coming this morning. And the papers that they have presented this morning are available on the website, and I'm sure that you will enjoy rereading the papers at a quieter time. But they're very well worth reading. They are very difficult topics, the two topics that were addressed this morning, and certainly the drawing of default notices leads to more than a sleepless night. For my part, if I can just add one thing, particularly to the junior lawyers, so often you encounter a vendor client that has the benefit of a contract which has to be completed within 14 days or 21 days, and before you arrive at the office one morning, you see them in the foyer on the 14th day wanting a default notice to be served because they feel very agitated about the fact that the contract isn't being performed by the purchaser. My experience would suggest that it is a very good idea for the solicitor to say, let's just wait, let's do this correctly, let's not, almost as a political act, deliver a default notice. It really needs to be done correctly and, regrettably, perfectly the very first time. And so if it were me advising the junior solicitor and supervising a junior solicitor, I would say wait and go slowly. And sometimes it's difficult because what the client wants is that hot little default notice delivered to the other side that day. Because mistakes are so often made in the practice of law by haste rather than caution, one of the challenges, I think, is to tell the client, and sometimes I think as a barrister to tell the solicitor as well, to just proceed with all due caution. Nothing is lost usually by 3 or 4 days in spending time in getting the default notice as right as it can be. But the opposite of having, in 2 or 3 months' time, a judge tell your client and you that the vendor notice has been drafted incorrectly and is of no force and effect, but has resulted in 2 sets of legal costs, is a very unpalatable day. So I would urge caution rather than haste, and I bid you haste to get to your desks by 9 o'clock. So thank you very much for coming.